Thank you. Okay, we're getting ready to start in a couple of minutes, and we have a packed house. At North Stone Country Club. So I'll start in about 1 minute. It's pretty big. All right, so we're going to talk about estate planning and elder law this morning and how to protect your assets. So I'm getting ready to go. Hey guys, I'm going to hand this off to you just to film me, okay, for this thing. If you guys want to pull shifts. I don't know, you taking first shift?
Yes, sir.
Okay.
All right. I'm good.
I'm Greg McIntyre with McIntyre Elder Law. Thank you so much for coming today. We're going to talk a little bit about estate planning, asset protection. We'll get into elder law. And you guys are going to give the seminar this morning. Is that okay? I'm going to ask plenty of questions. I'd love for you to ask plenty of questions. If you have any questions, just raise your hand or speak up or throw something at me, and I will do my best to answer those, okay? So, and I'll do my best to get you out of here in time, okay? So that's why usually we start, we allow you some time to eat, and then start up about 30 minutes into the event. So thank you very much for coming. It humbles me that all of you guys came out on a Saturday morning. And I love doing breakfast events because, I don't know, there's just something about, it's too early in the morning for me to actually get stage fright, you know? So,
well, it just makes it everything important. Breakfast is the most important meal. Estate planning is important.
it is important. Thank you. You want to get, thank you.
No.
You're going to give us okay. So this is me. I am an attorney with McIntyre Elder Law. I'm the managing attorney there. We have 3 offices, one in Charlotte, one in Shelby, North Carolina, and one in Hendersonville. Hendersonville is just outside of Asheville. So, we cover the majority of Western North Carolina. And I'm a member of Elder Council. I'm very honored to be a member of Elder Council. It's a national group of elder law attorneys. So it gives us a very deep bench. We go back and forth on legal issues with attorneys across North Carolina and across the nation. So there may be an attorney that has a problem they're dealing with that they post on our listserv, and I'm able to chime in and help, or vice versa, right? There may be something that I haven't seen before, just something really unique that I might get a great idea from another attorney who's working on it from a different angle somewhere else on the planet. The name of our firm is McIntyre Elder Law. I named our firm that a long time ago. 2 reasons. 1, to tell you what we do. And I still have people come in our office and ask me who Mr. Elder is. So is that my firm? And another is to tell me and our firm internally what we do. Because that way I don't take someone's speeding ticket or other type of case, okay? Just so we really stay focused on what we do, which is estate planning and elder law. So what is elder law? Does anybody know? What is estate planning? We'll start with. What's estate planning? Protection, sure. Anything else? Legacy, leaving a legacy. Okay.
And apparently you geared towards the elderly.
Well, we certainly do elder law. okay? Which is a subset of estate planning. But we do estate planning across the board, okay? And have for years. But, you know, when you're talking about a senior population or looking at that area in elder law, you know, they have a specific set of concerns in retirement. There is a bit of a legal maze out there for a lot of different reasons. When you're talking about protecting assets, when you're considering the possibility that none of us want to face, which is long-term care and the cost as we age. And so those are the things you take into account. So it just depends on how we're planning, what we're planning for, the considerations, or you know, what we're going to take into account. I think elder law affects everyone. Estate planning affects everyone. It affects your legacy. It can affect you, certainly, but it can also affect others in your family in positive and negative ways, depending on how you set up your estate plan, okay? So I look at elder law as happy law. If I were arguing in front of a judge and a jury, which I have many times, and we still do a lot of trial work around probate estates, will caveat cases, guardianships, things like that. But if I'm arguing against the district attorney, I may have a client I don't feel really great about. We may win in front of the jury. They may, you know, decide for us. They don't feel really great about it. The prosecutor's not happy. The judge may not be happy. But we did our job. At the end of the day, with estate planning and elder law, when we've saved homes, when we've saved retirements, when we've helped people pay for assisted living or nursing home care, when we, you know, successfully represented them in a case, you know, to me that's happy law. That I feel great about it, and everybody's happy. So I really enjoy this area of law, which is why I do it. So we all have our whys in life. I think your why is probably as or more important than anything else. Why you do what you do. So one of my whys, or some of my whys, are on this screen. I have my grandfather, which I know everybody can't see. That's Worth McIntyre. He's probably in his maybe mid-90s there. He lived to be about 99 years old. A little over 99. Almost 100. And certainly I saw Worth McIntyre. He was an extremely hard worker, had 6 children. My dad was the youngest of those children. He was a furniture maker and tenant farmer, really dirt poor to start with, and ended up buying a small farmhouse, okay? And in the end, he was left with nothing. And I didn't think that was fair because of the high cost of care. And he was in assisted living for around 14 years, okay? And really just lost everything, even sold his truck in the end, which his truck, you know, he would trade a truck it seemed like every 2 weeks, okay? But he was a great guy, one of my inspirations for the elder law part of it, okay? Without a doubt. These are my 6 children. Those are certainly my inspirations because daddy has to work, okay? And I love what I do. And I guess they say if you love what you do, you never work a day in your life, right? But yeah, I eat, breathe, and sleep what we do. So these are our 2 boys who are our oldest and our 4 girls. They're a little older now than that picture. This one's actually a 1L, which is a first-year law student. And this was getting ready to graduate high school. And this one's 14, 12, 10, and 8. So that picture's a few years old. I need to get an update. And then that's my wife, Stephanie, and who is the mother of our 6 children, okay? So, you know, that's my why. What is your why? What is your reason for being here today? Does anybody want to speak up and tell me?
Yeah.
Sure.
My mom.
Hello, Mom.
This too. My mom's gone.
Oh,
Yeah,
my
yeah, she
mom.
loves my mom.
Okay.
She's got more kids than, I ever were.
Sure.
But she is now in assisted living.
Okay.
At Trinity Oaks. Mom and dad really didn't have money
Mm-hmm.
or anything like that, and mom's brother had passed away, and his estate was split between two people, mom being one. And she inherited a large amount of money,
Right.
and still being very frugal. She's worrying about, oh, I have to leave money to all of you guys. I'm like,
Right.
no, we don't want it.
Right. Use it to take care of you.
Uncle Ed left you the money.
Sure.
It's for you. But she's concerned about it.
Sure.
And then my husband David, his parents are at that point where they need something.
Right.
So, and then we're thinking for ourselves too. Might as well start getting some information.
Sure, absolutely. Well, thank you for coming. Anyone else? Well, that's a very good reason for being here, right? For yourselves and for your parents, and you have your mother here. So thank you for coming. I appreciate it. I think the why behind why we do things is extremely important. So getting into some education in estate planning, we're going to cover 3 areas today. And this is really how our firm's broken up and how I see estate planning. The estate planning part, in what I call really pre-planning. Benefits planning, which is, if we need care, how are we going to pay for it? That could be private pay. That could be long-term care insurance. I'm not an insurance salesman, but we do recommend long-term care insurance heavily because of the high cost of long-term care. I see that as much as a legal tool as a financial tool. Or a veterans benefit, like veterans aid and attendance. I'm a certified attorney through the U.S. Department of Veterans Affairs and a veteran of the United States Navy. And we help veterans and spouses of deceased veterans with veterans aid and attendance pension benefits, which can add a maximum of around $34,000 to their income every year, which can be super handy if they, somebody needs some in-home assistance or assisted living care. When you get into nursing home care costs, generally the costs are really too high for most folks' income, even with that benefit to cover. So we might have to look at another way to pay for that. And then probate, okay? So we'll hit all 3 of those. And I will start with foundations, because this is where we should start. Many times I sit down with clients and they already know exactly what they want. And they want to start, they want a trust, or they want certain complex legal planning, but they really haven't thought about where they need to start, and that's the foundational work, because that's extremely important. Just like your home, you start with the foundation, right? You don't have a firm foundation, you're going to have a problem, okay? And trusts are important too. Those other parts are important as well, but we'll start with foundations, okay? So the 4 foundational documents we'll cover in the beginning are general durable power of attorney, which is also called a financial power of attorney, a healthcare power of attorney, a living will, and a will, okay, which may or may not be the best place to pass your assets, all right? There's many ways to pass assets, a will and the probate process being one of them, okay? And there's advantages and disadvantages to usually each way, and including the will. So starting with the general durable power of attorney. This is Mr. Foundation. She's going to help me. So a general durable power of attorney. What is a general durable power of attorney? Or a financial power of attorney?
Just giving someone permission to act on their behalf.
Okay. In what way?
Financially, maybe helping with their retirement accounts,
Okay. Helping with retirement accounts.
being able to, all of your business. Yeah, just kind of know what's going on with the retirement account, see how you can access the funds for them.
Accessing funds, right? Okay. Does it have to be recorded at the register of deeds?
No.
I heard a no.
That means you don't know.
So You will have a problem using a financial power of attorney if it is not recorded at the Register of Deeds. Under the old statute, which just changed a couple of years ago, there was a mandatory recording requirement. Now, there's not a mandatory recording requirement, but we still record every one, almost. Unless the client's like, no, I don't want to record it, okay? Because you will have, the bank will require it, any financial institution is going to require it, and you will have practical problems using it, okay? So you would want to record it at the Register of Deeds to put everyone on notice that this financial power of attorney is in existence and who's allowed to operate as you as an agent, okay? That's what the new statute calls it. It used to call it an attorney in fact. Now you're someone's financial agent. There's a principal who generates the power of attorney document. You hear all the time people say, that's my power of attorney. Well, actually, your power of attorney is the legal document, okay? That's the legal document that appoints someone as your agent. You may be the principal in that agent. I appointed my father when I was on an aircraft carrier one time to purchase a new Camaro for me, okay? And have it waiting on the dock when I got off, all right? That was a limited power of attorney, and I gave him the agency to be able to do just that, right? A general durable power of attorney, as opposed to a limited power of attorney, would give someone broad and general powers to act as you financially. And we would want to include, depending on your wishes, but I would advise to include real estate, financial accounts, bank accounts, stocks, bonds, annuities, investments, right? Insurance, really anything that you can do, apply for benefits. You want the other person to be able to do that. Should you trust the person that you appoint 100%?
Yeah.
Why?
Because they got power of attorney. Because they can take your stuff.
Yeah. I mean, I've got another Camaro out there, and this is the keys to it, right? It's handing them the keys to that, it's handing them the keys to the house, and trusting them with it, right? And your money, okay? And many times I see folks they want to limit. They say, okay, I only want this person to have power if I'm incompetent or incapacitated, or they want to put certain limitations on it. Generally, though, that's an indication that they do not fully trust the person they're going to appoint. If you do not trust the person you are going to appoint as your financial power of attorney, 1,000%, over the top, there's no question, then you should not appoint that person. And I would recommend against you appointing that person, or even doing, if you don't have someone in your life, and I have a few clients who just have no one that they trust to do that. And my advice is always, well, you shouldn't do one, okay? That's what guardianships are for. Guardianships, financial and healthcare powers of attorney allow you and your family to avoid court proceedings called guardianships. Because you can appoint someone if you become incompetent or incapacitated to handle your financial and healthcare affairs. So you can be proactive. I have one child, the one who's in law school, who's very proactive. He will have his homework done a month ahead of time, okay? My other child that I showed up there, my youngest boy, who's getting ready to graduate from high school, and he's a super smart kid, but he is not very proactive, okay? He lives very much in the moment, and he does not have his homework done a month ahead of time. Sometimes he doesn't have it done, okay? All right? So, but we're very proud of him, and he's going to run track and cross country next year in college, okay? But, which one do you think does better in school? The one that's proactive, right? The one that doesn't procrastinate. So that is an excellent way to be proactive, to plan, if you have the people in your life that you can trust to play those positions. If you don't, then that's what guardianships are for. But you can avoid guardianships by appointing the right people. And what you avoid are the higher cost, the court proceedings, and perhaps a judge not appointing the person that you want to be over your health care and your finances. And if your family doesn't agree on who the right person should be, the default knee-jerk reaction of the court is generally to appoint a public guardian. So you can have a corporate guardian over your money. And also the court has oversight on how that money is spent, which may be very different than how you would like it spent, especially if you're married, okay? Because all of a sudden, many of your assets are somewhat frozen unless you petition the court to spend money on something, right? It's a very narrow window or list of things you can spend money on without petitioning the court. And then they are reluctant to allow any of that money to be spent or moved for anything but care, okay? Food, clothing, shelter, care, all right? So you can avoid all that by appointing your trusted individuals in your general durable power of attorney on the financial side, okay? So I think that is probably the most important document that you could start with or have in your estate planning arsenal, because that's what it all hinges on. If you have not done your estate planning, if you have not gotten your affairs in order, and something happens to you because of accident, illness, or injury, your family members may come to an attorney like me, but they would not have the power to hire me or do any planning on your behalf, sign any deeds to say protect your home if you hadn't, properly done that. If you had not granted them that agency through a document like this, okay? So this can really put the brakes on everything. Then we're left with guardianship and then petition the court to agree with our estate plan. Does anybody have any questions about a general and durable power of attorney? Yes, ma'am.
In a law office like yours, do you have people taking that responsibility? And if so, do we pay on a yearly basis? My family's out in California.
Sure.
It's like, I don't mind.
Yeah, I've had many people ask me or someone in our office to serve as a financial power of attorney. I am extremely reluctant to do that, okay? Really. Because what if your family doesn't agree with all the decisions I make? As your attorney, I feel like I have to be your advocate and stay in that position, okay, to help you. I don't want to put myself potentially in an adversarial position against you or your family.
Or what if you had everything right now?
Or subject us to any liability, okay? And I see a huge problem, all right? So that's why I'm reluctant to do that. CPAs are well positioned to play that role sometimes, and I work with CPAs who are willing to do that because they're handling taxes, they're handling the finances. I'm handling your legal side, and that's where I want to stay, is in that lane, okay? Plus, I don't want to risk putting myself in an adversarial position with you or your family because of how I decided to spend your money, okay? And I don't want any appearance of any impropriety or any questions raised around that anywhere within 100 miles of me.
So you have a boundary.
So I think that's a bad idea for me.
To me, it seems like how can they shouldn't even question the lawyer though. I
know, man. Lawyers should never be questioned. I tell my wife that all the time.
But I have a POD
Yeah.
out in California, so that solves just the money part.
Mm-hmm.
And that's all they're interested in.
So you have a payable on death person. That's what you're saying. You have a payable on death beneficiary on some asset.
Right.
Yeah. So they're a beneficiary, right?
Right.
Can a
They walk
benefit?
into
You raise
Mr.
a
Jones
you raise a
and get their money.
perfect question. Perfect question. So I get that this is a misperception also. So I get this all the time. It's either, but we're married. I have access to all his things or her things, right? No. But I have beneficiaries, right? Payable on death beneficiaries on insurance or accounts or investments. They can handle that. No. When does a beneficiary have any power?
When
My beneficiaries only have any right to even make a claim to my assets when I'm dead. Okay? During my life, try calling as my beneficiary on my life insurance or my bank account or my investment accounts and trading some stock for me or doing something for me. What do you think they're going to tell you? None. You have no access, no control. Those things are completely frozen. And what that can do is that can prevent you either have, it just forces a guardianship. Because somebody has to have access if somebody needs to pay for care, right? Pay the bills, whatever needs to be done to operate your financial world, okay? That would be what would happen, is a guardianship, okay? It's the only way anyone can get access. If you don't have an agent appointed under a general and durable power of attorney. And, you know, here's what's awesome about today's world. My father was the financial and healthcare power of attorney for my grandfather, okay? And my parents moved from this area to Savannah, Georgia, like in 2002. We've got email, scans, fax, phones. You know, you can really, virtual meetings. We're streaming Facebook Live this thing today, okay? You can be somewhere else with someone else through a virtual and digital window very easily and operate their life, okay? And communicate with their financial institutions. Probably many of the financial institutions you deal with every day are actually based somewhere else, right? So it's very easy for even an agent who's not in state, even in California, the great state of California, which I love, by the way. I lived in San Diego for a long time when I was in the Navy. I loved it. Love Southern California. Great weather. So yes, the real key for me is not where that person is located, and I don't think it should be for you. It's whether you trust that person, okay? It's whether you fully trust that person. And if you don't have people in your life that you fully trust, yes, you can hire someone and pick and choose wisely, okay, to play that role. But I would recommend, like, who do you choose, right? Yeah, I would recommend a CPA. And I'd be glad to speak with you, you know, outside of this setting, right, on some potential solutions for you, okay? Because I think we could help.
I wouldn't put POA on any of my friends or anything. They're all my age and their spouses are dying, and it's like they don't have time to handle
Sure.
them.
Yeah, they'd just be like, let's talk about some potential solutions, okay? I think there are some. I just don't think that your estate planning attorney is necessarily the best option, okay? On the financial side, to handle the finances, all right? For some conflict reasons that I perceive, all right? And that's to protect me and you. So, any other questions on a financial power of attorney? Very good questions, and thank you. Okay.
Can I ask one?
Yes.
So is that in case you're incompetent? I mean, not, well, I mean, that you're, you know, not disabled, but are not able to make good sound decisions is when that power of attorney would come into effect, or could it be any time?
It could be any time. You can write a financial power of attorney or a general and durable power of attorney as a springing power of attorney. That's what that's called. A springing power of attorney only has any power. It springs to life if you say, or if certain conditions are met. So we might write it, you might want one physician to verify that you are not capable of making your own financial decisions. And we attach that physician's affidavit to the general durable power of attorney if that ever happens. So the bank or any financial institution or any deal with real estate, whatever's going on, will know that this person has power to act for you because on this date your doctor said this, okay? It could be, some people want two physicians. They're not okay with one. They want to make sure that their family doesn't, or somebody doesn't find some, you know, for-hire physician that'll just sign an affidavit, you know. And so yes, and you could write any number of conditions in there, okay? Usually though, when I see folks that only want springing, it's really, there's a deeper problem. And the problem is what we were talking about in the beginning is they really don't trust their family or the people they're going to appoint. So I'm going to try to drill down on that and see if they should have one at all, okay? Because, here's the reason, if you don't trust someone, you think they're going to take advantage of you now, while you're alive, well, and having breakfast at the country club, then they are absolutely going to rip you slap off if you are incompetent or incapacitated, okay? So it's not a good person to appoint, okay? Does that make sense? Yeah. But can we write those? Yes, we can. And we do. Maybe 1 out of 10, or less, okay? That I will agree to do that, because I have drilled down and I feel confident that you're appointing people you trust, and that this is just something that you feel confident about. I mean, I have folks that, you know, are just so confident in managing their finances and having that control, that at this point, and there's a misperception also that you would be giving up control. You're not. You're just also adding someone else to be able to help. Okay? It doesn't in any way it doesn't devalue you. It doesn't take away your power to do anything. Okay? It actually strengthens you, because you have another party out there who can help. Okay? Yes.
But it's only good when you're alive.
Hey, that's a good point. See, I told you were going to give this seminar for me. You're reminding me of all the things I should be saying. A general durable power of attorney only has power while you're alive. If you pass away, it ceases to have any power. And we see clerks' offices and, you know, hit the roof with clients sometimes, where they'll go pull money or move money after someone's passed away before the bank or anybody knows they're dead. Because that's who has power after you pass away. The estate, and who's over the estate? If it's a will, it's the executor you appoint in your will. And you have to go to court and go to the courthouse and be qualified as the executor and issue probate letters. Then you go to the bank or wherever it is with those probate letters, and you're able to operate accounts and do those things, okay? So yes, while you're alive, another good point, the reason I say this is the most important thing you can have right now. When does a will have power? Only when I'm dead. Right? It's not worth anything. Not worth the paper it's written on while I'm alive. Nobody can do anything with it. I see people all the time too that say, oh, that's okay. We don't need a power of attorney because I'm the executor. Or they make a big deal out of the fact they're an executor while somebody's alive. You're not an executor until you're qualified by the court to be one. Okay? And you may not be qualified by the court to be one depending on certain factors. Okay? But yeah, executor has no power while you're alive. Your agent under a financial power of attorney has no power after you die. Okay? It's a great point.
What would determine that you're not eligible to be an executor or not?
A list of items in the statute, which Nathan and I looked at earlier this week, is if you're a felon, you have to, if you're under 18, there's a number of others, okay? But they're basically a suitable person that is not a felon over 18 can be an executive, okay? How about that? Someone may challenge your right in the family to be an executive. That's another thing with wills. Is, you know, it's a court proceeding, and you can have family members come in and try to invalidate the will, you know, file will caveat suits. There's a number of reasons why you can do that, which is extremely important to have your will legally drafted correctly and tight so that it is probatable, number one, and then so you don't leave room for challenges, okay, or as little as possible. You know, someone may come in and challenge someone's competence when they wrote the will. They could challenge, you know, undue influence. Maybe, you know, hey, mom was living with my brother for 2 years and she really was under his power and control, and he came to the appointment and, you know, he was kind of dictating things, and these really weren't mom's wishes, okay? There's a number of reasons to challenge a will. I really enjoy picking things apart with a critical eye. So sitting down with a will and figuring out how either this should not be probatable or how it can be picked apart is something I enjoy doing. So you don't want someone like me picking apart your will one day with somebody else in your family. And I hope your family is perfect and harmonious and it gets along, okay? But everyone's family isn't. Plus, sometimes money after someone passes away is like blood in the water to sharks. I mean, you know, it's amazing what people will do for a little cash, okay? You know, and just, I have those 6 beautiful kids, and they look so lovely in that one picture where we were able to get them to sit still and all like stand together. Okay? That was probably one of a few times since they've been alive that you can do that, you know? And they wouldn't agree that tablecloth was white. I mean, you know, they would argue over that, and then it would end up in some wrestling match. And I've got so many of them, they'd be all over the floor, you know? So, really, I don't know that families can be described much differently than that, even when we so-called mature, you know, as mature and educated adults. Sometimes we just fight differently, okay? But you can solve a lot of those problems with estate planning, okay? So, any other questions on the power of attorney? I'm going to cover the will before I get to the will. Healthcare power of attorney. Nope.
You were back, you were
There.
Healthcare power of attorney. So, all right. I'm going to contradict myself. This is also pretty easy. Would it be important for me to appoint someone that I trust to make life or death healthcare situations if I'm in a situation where I'm incompetent or incapacitated?
Amen.
Okay.
Not necessarily.
Not necessarily. I heard amen and not necessarily. See, people don't agree. So, all right. Why do you say amen?
Well, both me and my husband were not expected to live last year.
I'm sorry to hear that.
And he passed
Glad you're here.
away, but
I'm
I got
sorry.
to be with him to the end.
Right.
And so you have to fully trust the people in charge. And if you have even an ounce of doubt,
Right.
do not use them.
I would totally agree, both with the financial and healthcare agent.
In all of it.
Yes.
If you
Yes.
check in your spirit or heart at all, choose someone else.
Yes, ma'am, I agree. And why would you say maybe not necessarily?
I said that because if you have a family member who doesn't go by their wishes, and, oh, well, the doctor says there's a chance, or, no, I have faith it's gonna work, and the person is brain dead and everything, that there's no reason, it's okay, we're gonna keep it going, versus going by their wishes and saying, hey, listen, if I'm on a machine for more than 24 hours.
So you want someone who understands your
Like
wishes.
some
and who-
family members-
Who you trust to
Some
carry
family
that.
members might
Yeah.
want to
Yeah.
hold on to you for.
So I think that goes back to the fact that, say, that's where I picture me, is like, you know, I'm suffering, maybe I'm in a persistent vegetative state, or maybe even just a decision needs to be made about a surgery or a procedure or something, and my 6 kids are trying to make the decision, right? And I can see that just being a problem for them, okay, and trying to reach an agreement, okay? So I'm a huge fan of appointing. Now I have people appoint multiple, okay, to make the decision together, but I don't see the practicality in that. One quarterback to huddle up with a family, reach a decision, and run that play into the doctors, the staff, the nurses, care facility, whatever it is. No one will tell you that's more important than somebody who works in a care facility or works in a healthcare profession, okay? Having one person to send a clear message, because it's very hard to give continuity of care and just really good care if you're getting mixed messages. It's hard to be in any relationship where you're getting mixed messages, maybe from different parties, okay? So having someone who can clearly communicate that message to the healthcare providers is extremely important. And I recommend one trusted agent. Now, should you, just like the financial power of attorney as well, this applies there, should you only have one, or should you maybe have a sub or a backup? Gosh, if you have more than one person in your life that you really trust, having a backup is extremely important as well. Because if the primary is not capable of carrying out that duty, or for any reason, maybe doesn't want to, or predeceases you, then you have no one, okay? So I have some folks that will appoint a secondary, some will go 3 deep, some 4, okay? It just depends on the people in your lives and who you trust.
And you can
Okay?
say that, but couldn't you also say they can act independently or they have to act together?
You can. In the financial power of attorney, however, if you say they have to act together, starting a couple of years ago, we started having clients that had problems with the financial powers of attorneys that we wrote, that where we had 2 people that had to act together. Because what the banks did, probably because they got sued, because maybe two or three people had to act together, but maybe the banks have many employees, maybe a teller at a bank, who said, okay, well, I see there's a power of attorney, you're one of them, here's all the money or something, right? And the other 2 were like, whoa, we had to be there, okay? So they don't want that liability, so they will allow you to appoint multiple at the same level, jointly and severally, so they can act independently or together, but they won't honor those or allow you to use them in our experience over the last couple of years if you make them act together and agree. Plus, they might not agree. I mean, I think you're setting yourself up for conflict. And who's the tiebreaker between 2 people? Right? Yes, sir.
I was under the understanding that a living will, is carried out according to your own wishes. Am I
Sure.
right?
I would agree with you, and
So it can't be changed by any of your family, right?
I would agree with you.
I worked in a hospital, so we go by
Sure.
living will.
Yes. Well, you go by a healthcare agent first. And that's what we're talking about right now, is the healthcare power of attorney. And I'm glad you brought up living wills, because that's a totally separate document. But we'll get there. We're getting there, okay? So thank you. It's a little foreshadowing for where we're going next, right? So a healthcare agent, okay? Anybody know what HIPAA is? So it used to be fairly easy for me to get medical records, okay, as an attorney. Now, no one can get your medical records without a HIPAA authorization, a signed HIPAA authorization. So it's important that your healthcare power of attorney also have built in a signed HIPAA authorization within it. If you want your healthcare agent to be able to pull medical records for you, to seek a second opinion, maybe to review them, to have them reviewed by someone else. Or you might want to know why an aspirin costs $400. I don't know. But there's a number of reasons why you would want to give your healthcare agent the ability to pull your medical records, okay? And that's how your healthcare power of attorney should be written, okay? I don't want to see you stuck in a situation with no one to make your healthcare decisions, or anyone. And again, you avoid guardianships there. That's called guardianship of the person. 3 types of guardianships. Guardianship of the estate is over the money. Guardianship of the person is over your healthcare and placement decisions. Or there's general guardianship, which is over both, okay? A general guardian. Could be the same person. And you can be proactive and appoint the people you want to be over those decisions. And that's very important. Yes, ma'am.
I have 1 child,
Mhm.
and so would you recommend I still do this and have her to be like the power of attorney for?
I don't know your child, but you do. Would you recommend that she would be, do you think that she's a good person to make your decisions?
Yes.
And she brought up something very important too. It's important to communicate with the people we appoint. Communication helps everything, okay? So if they know your wishes, right, and they're clear on what mom would want to do, yes, that's extremely important, if you trust that child.
So she would, I ended up in a nursing home quickly.
Right.
She wouldn't have access to my money or any of that kind of stuff without that power of attorney. correct?
Without a financial power of attorney, she wouldn't have access to any financials or real estate or anything else, or bills or anything,
Okay.
right?
Then you have to probate.
I mean, my wife can't call the phone company and do anything with our account, like our mobiles, because I set it up, right? I mean, everything, just even the smallest things, you would need a financial power of attorney.
So that's
On
that's a good thing
healthcare,
to have.
healthcare, you would want to appoint someone to handle healthcare issues through the healthcare power of attorney. That's right.
And
Yes,
it's big.
Is it possible to have one, one or two people handle your health care, but not necessarily your financial?
Sure, and that's why those things are separate. That's right. And in fact, out of my 6 children, one of them may turn out to be a whiz with money, and I want him or her to handle my financials. One of them may turn out to be a doctor. I don't know, right? Or in the healthcare field. And I'm like, they're perfectly positioned to make my healthcare decisions. So you can appoint just one. You can just have one aspect done and covered and leave the other one uncovered. Or you could do both and have different people appointed, okay? It's your choice.
And going back to what I had said and what you had said, I mean, it's one of the big things that my husband and I are both in the medical field. And he does not want anything done. He wants a tattoo of DNR on his chest.
Oh, I got a story about a guy who had DNR tattooed on the neck.
Yeah,
We'll
so,
talk about that in a second.
so if he collapsed in front of me, technically he does not want me to do CPR, he just wants to go. To me, that tears me apart.
Yeah.
But he has seen enough people go through all of that. And if they do come out, I'll never want to do that again.
Yes. But unless he has a DNR, they have a mandate to resuscitate him. So that we'll start with the DNR when we talk about a living will. Because this is, people get so confused. They confuse these documents. So that's a good place to start.
But
Okay?
knowing what somebody
So-
wants is really important.
Communication is extremely important. In anything, right? In any relationship, okay? Because we're human beings. Keeping everything in our head doesn't allow anyone else to know what's in our head, right? So, okay, there was a gangster in LA, and he had DNR, really big and fancy, cool looking tattoo right on his neck, right there, okay? And great guy, you know, your daughter would love him, all right? And you know, so paramedics came out, and you know, they had a hard time figuring out whether they needed to revive him or not, okay? Right? Because he had DNR tattooed on his neck. It made news, it made national news, okay? As I read the article. And so a DNR, though, it stands for what? Do not resuscitate, okay? That is not what a living will is. A DNR, do not resuscitate, is between you and your medical professional. So you and your doctor can sit down and talk about it. Many times, it's folks that have been through a long, extensive process. Maybe they have coded before and been brought back, and they're at the end of their journey. And they're making the decision that if this happens again, do not resuscitate me, okay? And you'll see those, you know, posted over folks' bed. I've seen them on the fridge, right? But that is an agreement between you and your medical professional, okay? If I have a heart attack right now, please, somebody resuscitate me because daddy's got to work, all right? But I do have a living will. But a living will is a legal document that says if I'm terminal, incurable, in a persistent vegetative state. That means not for like a day or two, all right? So this is a long vegetative state. And I'm terminal, like I'm going to pass, okay? And the only medical procedures that can be done are going to prolong my suffering. It's my voice in the room when I can't speak saying, hey, medical professionals, family, healthcare agent that I appointed, this is what I want and it's okay to let me go, all right? That's what a living will is. And it's releasing them from liability for letting me go, all right? So, it's both a legal and a practical document. It has legal significance in accomplishing its purpose, right, as it's written. But it has also a practical impact on your family, because if you've been through a situation where you've had to make a decision, or along with family members make a decision to let someone go, I'm sure it can stick with you, all right, and does. So certainly from a practical standpoint, I would hope my 4 little girls would struggle with that decision, okay, if I didn't have a living will. But I know that the living, well, hopefully my boys would too, but hopefully they all would, yeah. If I have a living will, it certainly tells them what my wishes are. If I've communicated that to them and talked to them, right, and expressed that verbally to them, they know that, hey, this is what Dad would want in this specific situation, okay? And I hope none of you ever, or me, wind up in that situation, but I don't know what the future holds for any of us. So a living will that's what that is. It's also a place where we can express certain religious requests. So I have a number of clients, well, from many different religions, but I have a Catholic living will that we write that has been cleared by the diocese in Charlotte, where if you're a Catholic, you want to make sure that last rites in Eucharist are administered prior to being let go. Okay, and any other religious preferences may want the family or some of the church and the pastor to come pray with you, or something like that. Okay, but that's where you would express those wishes as well, and that's the appropriate place to put those. Okay. So does anyone have a question about a living will? Okay, now we'll get into the will, which we've kind of already gotten into anyway. Oh, by the way, a living will is not a will. It's horribly misnamed by some dumb attorney, okay? It is a declaration for a desire for a natural death, okay? It's not about living, and it's not a will that passes your property, okay? I guess it maybe is your will and your wishes, but this is probably the most confused estate planning document by other people as far as what it does, because I've had probably several times a week folks say, I already have a living will. Okay, yes, one, I'd like to read it. Number two, that doesn't pass your assets. Oh, I thought it did. No, okay. And speaking about the hospital, I don't like how when you're coming in on a gurney and you're experiencing a traumatic healthcare situation, they try to slap a living will on your chest and just sign here, That's not the time to try to make a decision like that. I'm surprised they hadn't got their pantsuit off, for things like that.
Well, that's for
Yeah.
any, thing like that. They grab you or the family in your state of grief and shock and not knowing what's happening to
I
your
mean, you
loved
think you're in a
one.
position to make a really good, well thought out decision at that point? No, not at all.
Well, was there a reporting requirement? Your last question was the only thing that it is.
What's that?
Your last question on the living will, is it required to be reported?
Oh, no, a living will is, a healthcare power of attorney and living will are not recorded at the Register of Deeds. Those are not public record documents,
So
okay?
you said the medical and the living one?
Are not recorded at the Register of Deeds, okay? They have an elevated signing requirement, okay? So you have to have 2 witnesses and a notary on those, whereas as on a financial power of attorney, only a notary, so, yes.
So when you go to get something recorded, is that the responsibility of the notary, or is that a separate trip to the courthouse?
So not necessarily the courthouse. Some counties have Register of Deeds in the courthouse. Many or most do not. So that's a separate office, the Register of Deeds.
So if I were to get my father's will,
Sure.
we had it notarized. I didn't know if I'm supposed to take it somewhere to get it.
You're not.
Okay. I
And
thought
a
they
will
had-
shouldn't be recorded either. A general and durable power of attorney you should record before you use it. Okay. But a will is an entirely separate estate planning document, right?
I understand, right?
And I would not want my will publicly published, right? They are published publicly in a court file after you die, because you have to open up a probate estate. And you used to see in the paper all the time, great segue to wills, thank you. You used to see articles about, old man money bags or something, passed away, and how much money he had, where it was going, and stuff like that. You'd see that all the time, right? I don't see that anymore much, okay? But in your local paper, they used to write about it all the time. The reporters would go pull the court files, and they would look at the will and what it said. There's some funny wills that were published back then too. Very creatively written, okay? So Google funny wills or something like that. You'll get them back to the 1800s that were just, you know, really, really blunt and to the point about how they felt about their family members. And how they wrote it. Very eloquently written.
Yeah, who was that lady that left her estate to a dog?
To a dog? Yeah.
Yeah.
You can do that.
In New York.
You can do that. Your dog is your property, but you can also do pet trust and testamentary trust within your will. Certainly. I've never given it all in estate to a dog in an estate that I've written, but I have set aside money for the dog or other animals, yes. Did I answer your question at all, or do we need to get into that a
No,
little
so I
bit?
just need to, I also have power of attorney,
Yes,
general durability, so that was notarized.
Yes.
So I need to take that down to the registrar's office.
I hope that, yes, yes. Yes, it would need to be filed at the Register of Deeds before you use it, okay? If someone, the reason that's important is a general durable power of attorney needs to have a durability clause for it to be valid and usable if someone becomes incompetent or incapacitated, right? And at the point that it has to be recorded is after someone is incompetent or incapacitated for you to be able to use it. And if the durability clause isn't there, then it's not usable after someone's incompetent or incapacitated, okay? General durable powers of attorney are extremely complicated legal documents that people get wrong all the time. I'll give you an example, and this is the point I didn't hit, and then we'll run through wills. On a general durable power of attorney, okay, would it be important and a smart thing to do to limit my agent to be able to gift things to themselves? So to take money or property from me and gift it to themselves and move it to them. Yeah, yes, right? You say yes? Okay. Anybody else?
What was that question again?
Would it be important to limit
Yeah.
gifting for the agent? So, you know, you appoint an agent to be your, you know, financial person that's going to do things for you, stand in for you, and to limit the ability for them to give gifts to themselves or move money or property to themselves. Yeah, you want to limit that, right? Yeah. Okay. So I'll ask it a different way. Okay. You guys. Okay. So, you know what? Your husband came to me. He didn't. Okay, just hypothetically. If he comes to me and we write his power of attorney, and then, you know, heaven forbid something happens, and you're the agent, you're good, everything's good, okay? And you want to activate a benefit for him or position his assets correctly, so you don't have to spend them all down on, say, care or you know, you want to protect them, right? So maybe they're there for you, and maybe you guys worked your whole lives to accumulate this wealth or something like that, right? And all of a sudden you go to use it, and somebody, some attorney who's reviewing for the bank, you know, something like that power of attorney before they activate it and allow you access to the account, says, oh, well, there's a gifting limiting provision. What she's trying to do to move that money just to her sole account, that doesn't allow that. So therefore, you're blocked or handcuffed from transferring any assets that are just in his name to you. And beyond that, maybe you want to refi the house, and both your names are on the home, right? And you have to sign a deed of trust. And so does he, right? To give the bank the ability to foreclose if you don't make the payments. Maybe you want to sell them, right? Can you do any of those things if you're limited from gifting to yourself? No, that's a horrible idea for a husband and wife who love and trust each other. I mean, my wife would be totally handcuffed from doing it. Who would she have to get? You're essentially saying, hey, you can give to anybody on planet Earth. You can move this money, except to yourself, who's the agent, who's the most trusted person, and you're my spouse, right? So you need to think about those things when you write financial powers of attorney, because I see attorneys many times thinking they're doing the right thing by doing that, and they're actually preventing a spouse, for example, or a trusted child from saving or protecting assets or activating benefits, unless they give it to some third party, right? Which is not what you would probably want them to do, right? So, you know, need to really think about these documents as we write them. There's a lot of thought that goes into that, so just think about those, okay? So I'd be glad to review that financial power of attorney. will, whatever, okay? And I tell you exactly what you should do, okay? And if I sit down to review, I'm going through kind of a template that I have in my head from my experience to point out strengths, weaknesses, what I think. And I might tell you, hey, it's legally the way you need it, okay? Mine looks better and smells better. This is fine, okay? Right? But I'll give you an honest opinion, okay? So a last will and testament. We'll cover the things we've already covered so far. It only has power after somebody passes away. It has to go through probate, okay? You can appoint an executor. I'm less concerned about you. I want you to trust that financial agent more than the executor, right? I'm more concerned about the executor. The court watches over the executor, okay? So that happens through a court process called probate. And they have to do everything by the will and by the book and under the law, or else they get in really big trouble, okay? But you would want to, I still think certainly, appoint a trusted individual to be your executor, okay? Would be nice to have a backup or a sub in there in case that person predeceased you. We would want these things to last for the rest of your life. And then, is the will the best place to pass your property? And that's a big question. Are there better ways, tax-wise, to pass your property? You know, if you're at a wealth level where you might hit an estate or death tax limit or ceiling, trusts do a great job at doubling that exemption, okay? So that's important. That's where we might want to look at trust as an option. Wills can pass property immediately, lump sum to an heir, or over time through what's called testamentary trust that we build into the will that become active when somebody passes away and can control the distribution of assets over time. You may have children who you don't think would do well with a big lump sum of money. That might be important. You may have children or grandchildren that you might want to help go to college. So you might want to have discretionary language in a trust or testamentary trust, which Nathan wrote one of those yesterday, that says, for health, education, and welfare purposes, state your intent for this child to go to college or grandchild and to help pay for it with this money. And that's what it's used for until, say, the person turns 25 when they have a little more education, experience, age on them. And then maybe not even distribute lump sum then. You could, or say, then you might want to do, say, 10% a year over the next 10 years, right? So there's a lot of ways that you can structure the distribution of your assets. You can do all that in a will. Be aware that a will process and probate process, you have to post or publish in the paper for 4 consecutive weeks a notice to creditors. So if there are any debts that you have, such as Visa, MasterCard, any healthcare expenses over the last year of your life, or let's say Medicaid had to come in and pay for extensive assisted living or nursing home care, then where Medicaid or any other person you owe money to when you pass away collects that money is during that 90-day window, they have the time to submit a claim. And that's what they do to the probate estate or to notify the executor, okay? And then if your home, for example, or any other assets are passing through your will, then if the liquid assets in the estate aren't enough to pay those claims, then your home is sold to pay those claims. So there are also ways to avoid collection of assets, especially if long-term care and payment of long-term care can be an issue, and you might have to roll to Medicaid to pay for that, okay? There's many ways to protect the home and still stay in control of the home for the rest of your life. There's a couple of different ways. Trusts are great for that. Irrevocable trusts are best for that. The difference between a revocable and irrevocable trust is you control the revocable trust. You're avoiding using that for probate avoidance. Probate can also take an extended period of time. And I always try to tell my clients that up front. Minimum 6 months. I mean, you've got a 90-day period in the middle that you just are on hold for claims to come in. Minimum 6 months. Because there's multiple filings, that have to be done as well, okay? Yes, ma'am?
So when a will goes to probate,
Yes.
does,
When you submit a will to probate.
who pays for that probate?
There are filing fees associated with the probate. Many times, attorneys are hired to handle the probate process and navigate those legal waters. That's absolutely, I preach all the time about avoiding probate, and that's by far our largest department. We're probably doing 300 plus probate cases right now, across the state.
So we would have to pay the attorney fee if it went to probate?
Oh, okay. Could be. Sometimes the client will pay up front and they get reimbursed out of the estate.
Okay.
Sometimes the estate, if it's sizable enough, we'll take a percentage fee. I know that's what our firm does, of the probate process, right, which is capped at 5%. Yes, so the estate can pay that, okay? The estate can pay that probate fee. But I really, one thing that is good to think through and discuss is whether a will is the best and most primary place to pass your assets. Because if there is a potential for a claim, then you would want to structure your assets to pass outside of probate. For ease of administration, trusts are extremely easy to administer. The trustee, which could be a trusted family member, could be a spouse, could be a child, stands in to control those assets. The trust lives on and survives you, okay? And then can distribute those assets as you have directed by getting with an attorney and just drafting deeds and signing them as the trustee according to the rules of the trust.
If you have a trust and you go into a nursing home,
Yes.
will your money still have to pay for the nursing home?
So, it depends on the type of trust, okay? So, if you were applying for a governmental benefit like long-term care Medicaid to pay for nursing home care, and you had your money in an irrevocable trust, which you control, it would be like this water, okay? This is very similar to a trust. The trust is the container. The water inside is any number of accounts or real estate, investment accounts, whatever that you have placed inside there, that you have named in the name of the trust, okay? Or deeds that you have written into the name of the trust, okay? You control it just like it's yours. I can break it. I can pour the things out of it. I can put other stuff in it, right? It's mine. I control it. So for a governmental benefit, they deem it to be yours. So it's still your asset, okay? So it's a countable asset. If it's an irrevocable trust, then, please hold this. She is now my trustee. Still my trust. She has a legal fiduciary duty to, I can still draw the income off that trust for the rest of my life, okay? Off any dividends or income that come in. If I die, it still has to be administered as I've written the rules of the trust, and she's legally bound to do that. But the government doesn't count it as my asset because she's the trustee. And the trust is irrevocable. I can't revoke it. I don't have any control over it, okay?
So the nursing home cannot get it?
That is correct. An irrevocable trust is a great way. We have a specialized irrevocable trust called a Medicaid Asset Protection Trust that works amazingly well for that. Okay.
For your IRAs and everything?
IRAs are a different animal. So retirement assets, if we're talking about trust, pre-tax assets, so tax qualified funds, IRAs, 401ks, and qualified annuities do not go into trust because you haven't paid your income tax on that yet. Okay? But what we do is we can look at an IRA to trust conversion plan. The same way, your financial planners know this too, or should, and they will many times at a certain point urge you to start a conversion plan to a Roth IRA, okay? Over time, to minimize your tax impact, but still keep it in a status where they're managing it, okay? And it's still being used for you, right? But yes,
So is it a Roth, is the different story?
if it's non-tax qualified funds, if it's in a Roth, we can absolutely have a conversation about how that works. Any kind of investment account can be held in a trust, but retirement accounts that are in that kind of pact between Wall Street and the government that you don't have to pay income tax until you take that money out under certain conditions, right? Which is, 59.5. If you take it out before then, it's a 10% penalty. You can start taking distributions after 59.5. And after the Secure Act passed 2 years ago, they extended the age from, I think it was 70.5 to 72, okay? That you have to start taking it out after 72. Your RMDs, required minimum distributions, okay? And you can keep investing in IRAs after that age now, which you couldn't prior to the Secure Act, okay? But I have those conversations on a regular basis in consultations, and I'd be glad to get more in depth with your specific situation. And I would give you exactly my legal advice on how I think we should accomplish your goals, because that would be, my goal is always just to see what your goals are and how to legally get you there, okay? And stay in control of assets for the rest of your life if possible, okay? And while providing options for healthcare benefits down the road or long-term care benefits, which I know are going to be a huge drain on assets, right? And that's the system we live in, right? That's the matrix we're in right now. Is that's kind of how it's designed, right? I'm not a huge fan of how we've gotten ourselves into positions of the majority of our wealth that we accumulate over life are in qualified funds. Okay, I would differ from a lot of financial planners who I think are starting to warm up to that, and I've been preaching about that for probably 10 years. And we've been in a position where we've had the lowest income tax rates like ever, okay? But still, we're leaving all our funds in these tax qualified places and not moving them where they actually can be protected at all. And then some people are forced into situations where they have to take things out lump sum or big pieces, and then they're really hit hard by the income tax that year, okay? And I don't think that's smart. I think you gotta plan ahead and do it over time, okay? And I don't think income taxes are going down, that's my point too. If they're sitting at the lowest they have been for a long time, I mean, you see the government right now, they're coming for more taxes, they're looking for more place to get, okay? The estate and death tax has been rumored, kicked around the federal level since midsummer, to come down significantly. But anyway, that's what my job is to plan around it. And people don't always listen to what I say, so that's why our probate department is huge, right? Did you have a question?
Pensions?
Pensions are not assets.
Not.
Pensions are income, like an NC State pension, for example, something like that, right? Pensions used to be huge, right? Every company had pensions, right? Now they're not, right? Governmental agencies, stuff like that. So a few others still have pensions, but pensions are not assets, right? And you can get into pensions a couple of ways. One is, generally you take a higher amount if it's not transferable to your spouse, or you can choose to take a lower amount and then transfer it to your spouse when you die. And generally, what the spouse collects is not at the level you collect. Usually it's half. But that's what I see. That's the general rule of thumb for pensions that I see. But they're not counted as assets because, you can't cash out a pension, right? It's just income for the rest of your life. But I can cash out my IRA. That's my money. It's just I have to pay income tax on it. And if I got a lot of money in an IRA, it's kind of stuck, right? That's why it's a great deal for the government and Wall Street, because your money's stuck right there. They know they got you for the rest of your life. So, anyway, yes.
My grandmother passed away, of course, at this age, and she left a will, and my uncle was in charge of it. And in the will it said there were 3 sections that he was to pay each of his sisters or brothers a certain amount. Now, he never paid it. Is there something, must he pay it?
What's your name?
Pat Klein.
So Pat said family member first had a will. He was supposed to pay a certain amount of money to 3 people and he never paid it. Number 1, was the will probated? Number 2, was the money there to pay? Okay? And yes, if you file for probate, you have to do what the will says. Number 3, were there claims that came in on that estate that forced the payment of what was supposed to go to the kids to pay this debt, right?
Yes.
Yeah.
It was a fair amount.
Sure.
that he got, and
Yeah.
the
I don't know why that wasn't paid, but I do know that if it goes through a will, the court will not sign off on it to close it out without a final accounting showing that that money went to those people, and without those people that received it signing receipts that they received. Okay? Mhm. So I'm not sure what happened in that specific situation, but that's how it
It
works.
was my uncle.
Yes, sir.
Beneficiaries.
Mhm.
So like if I have a life insurance policy and I have my beneficiaries, set up in that, that's a whole separate document.
Yeah, so beneficiary assets pass outside of the will and probate estate. It's part of your estate, it's just not part of your probate estate,
Okay.
okay? Right, trust assets, beneficiary, the whole concept comes from trust, right? Wills have heirs, trusts have beneficiaries, okay? Life insurance policies now have beneficiaries, right? Financial industry's adopted them. You can put payable on death beneficiaries on your bank accounts.
Annuities?
Annuities are insurance products and have beneficiaries. Okay? You can put payable on death beneficiaries on investment accounts if you have an investment company that allows it. Okay?
So which means at the end of the day, beneficiary is the beneficiary, boom. It won't have anything to do with the will other than what you have attested in the will.
It is not under the control of the will. That's correct. So you need to know what the will is actually going to control, and that's a great point. But it is a countable asset. So if you were in a situation looking at how am I going to pay for long-term care, right? We want to have that conversation, okay? About how that asset's positioned and how to, what works best to accomplish your goals, okay? So wills works great, has worked great for thousands of years, I guess. I think they talk about wills in the Bible, okay? And then like the Greeks would have verbal wills. I'm sure that worked out great. And then the Romans would have like a council of 7 you would stand in front of, right? And verbally say what you meant, but people remember things different ways. And even written wills are, again, subject to claims and subject to lawsuits, okay? For will caveats, things like that. And sometimes that is where assets go to die, okay? And do not pass as you intend. All right, so a will can be extremely important and work great depending on your situation and your goals. Sometimes trust may be a better option to pair with a will, and sometimes deed protection or deed planning might be the best option. Deed protection or deed planning would be, say, a life estate deed or ladybird deed, where you stay in control of your home for the rest of your life and then pass it automatically to the kids when you pass away. Ladybird deeds are not countable assets under Medicaid look-back rules. So it leaves you open for that benefit to pay for long-term care and still accomplishes avoiding probate and passing the asset and keeping you in control of your residence for the rest of your life. So those are huge tools that can be used to protect assets. We have tons of different tools in our toolbox to help people to do that. And I'm going to run through because I think I'm past where I should be right now. And I'm going to end up. We have quite a few attorneys. These are 3 of them. I think we need to update it. We have a couple who aren't there right now on that picture. That we're leaving out Eric and Theron there. Fine people who, this is some of our team. We're, I think, much bigger now even. But let's see. So I'm at the end, and I'm going to wrap it up, and I hope you guys have a great weekend, okay? And I wanted to thank you for coming. I do a lot. I do quite a few events per year, and we also do a ton of writing and education. One of the books that I wrote on estate planning and elder law is called Saving the Farm, a practical guide to the legal maze of aging in America. And I think we have a number of copies. Taylor, where are those copies?
Right here.
Right outside the door there as you exit, okay? I would be glad to sign one and give you one for free today, okay? And I would offer a free consultation, which is Our consultation fee is generally $150, okay? To sit down with my time and go over your situation, your goals, and how to achieve those goals. But since you came out today on a Saturday morning, I'd be glad to offer that free consultation to you, okay? And give you a free book for saving the farm. I mean, we have a lot of things that I work very hard to really visually display what we talk about. The estate planning map, for example, is something that's in our magazine that I'd love for you to have a copy of. The Ladybird deed map, we visually display how that works. And we have a trust map that displays how trusts work and the difference between revocable and irrevocable trusts. Because I can tell you about legal concepts all day, but it's much easier for me to simply look at something and see how it works, right? I can tell you directions on how to get to, 20, 30 miles away from here, but I bet you you'd remember it a lot better if you had a map in front, right? So I want to visually convey that to you, and that's in our magazine. And then we also have a cool book that my law partner, Brenton Begley, published this year called the Elder Law Handbook. And Brenton's a good writer as well, and I've published a number of books, and I helped him publish that book. It's my goal that our attorneys consistently write articles and really dig into what they do. There's no way to learn something or really get intimately familiar with it than research it and write about it, okay? So how's your book coming along, Nathan?
We're getting there.
Okay. But, I'm always happy to help people that I work with improve themselves and improve us as a firm because it helps us all. So the trust, the maps, the magazine, and the Saving the Farm book and the 10 rules of elder law. I'd love to give you to you today. That'll save you from having to go on Amazon and buy it for, I think they're like $20 or something like that. Okay? So thank you very much for coming today. I very, very much appreciate it for breaking some bread with us this morning and hanging out and helping me give a seminar and asking such great questions. Thank you. Thank you very much. Okay. And I'll see you after that.